Once again, good morning, everyone. Advocate Chauke, are you ready now?
Chair, I'm ready and thank you for the indulgence.
Yes, thank you. Advocate Noko, good morning, madam. Please let me know if you elect to take the oath or affirmation. The oath. Do you swear that the evidence you are about to give will be the truth, nothing else but the truth? If so, raise up your right hand and say, "So help me God." Yes, thank you. Perhaps before you begin, on behalf of my sisters, the panel, allow me to thank you for having made yourself available to come and testify, having been given a very short notice. You will appreciate, and I'm sure it has been explained to you, that you are here at the instance of the panel for reasons that are known to you now. Once again, thank you. You may proceed, madam.
Thank you, Chair. I think I also need to just thank her because she did most of the heavy lifting, preparing her own affidavit. I did minimal, so I just wanted to also thank her for that.
Thank you. Thank you, Counsel.
Advocate Noko, in front of you is a file. And in that file, on the top should have, you should have a document titled affidavit. Do you have that in front of you? It starts at page 1.
Yes, I do.
Can you confirm that those are your names? And
Would you please, madam, maybe because we, including myself, from time to time I forget to switch on the mic. Maybe if it is convenient for the subscribers, just keep it on so that you don't forget. Thank you.
Yes, Chair.
do you confirm you have that document in front of you?
I do.
And at the bottom page of page 1 of that document should be initials. Are those your initials?
They are.
Right. And if you turn to the very last page, which should be page 20, rather page 19, page 19, just above the line that's written deponent, can you confirm that's your signature?
That's my signature, yes.
All right. On page 1 of the document, you have described yourself, and it's paragraph 1 and 2.
Yes.
Can you, for the record, just state your names and introduce yourself, your credentials? Can you do that, please?
Okay, I'm Moipone Noko. I have a BUris degree. I have an LLB degree postgraduate. I have a Master of Laws LLM. I have a certificate in advanced labor law from various universities, University of Limpopo, University of Pretoria, Vista University, and University of South Africa. I've been a prosecutor since 1997, in various ranks from district court prosecutor, regional court, state advocate, senior state advocate, senior deputy director of public prosecutions, and director of public prosecutions for 2 provinces, being KwaZulu-Natal and the Northwest, until February, March 2021, when I had to leave the service of the National Prosecuting Authority.
Thank you. And then paragraph.
This, I beg your pardon, ma'am, these credentials appear somewhere in your affidavit when I read it online. Which paragraph is that?
Yes, they do.
Paragraph 9.
Yes, on page 3, yes.
Yes, on page 3. Yes.
Thank you. And just after your description, you have a topic there that says purpose. Can you just take us through the purpose?
As per my understanding, the purpose of me being here as a witness is to testify at the instance of the inquiry. And I can assure the inquiry that I'll be as brutally honest as possible to the best of my ability.
And you said you understand that you are here to give testimony as a witness in the inquiry. That was in paragraph 3.
Yes, for the inquiry, yes.
Okay.
If I may, and you do understand that you understand that this inquiry is mandated to inquire into these issues that are raised in the terms of reference. I suppose that the terms of reference have been made available to you, or
Yes.
at least you have a broad understanding
Yes.
of
I-
the terms of reference.
Yes, I do have a broad understanding.
And our task as a panel that has now called you to testify is to search for the truth,
Yes, Chair.
to be able to make a recommendation to the President
Yes, Chair.
about whether Advocate Chauke is fit to hold office.
Yes, Chair. Yes, Chair.
Thank you. Proceed, Counsel.
Thank you, Chair. Before we move on to the relevant events, is there any other thing that you want to put before the panel?
No.
Advocate Kowe, as an advocate, you know in court we speak loud.
My apologies, Chair.
Please speak up so that
I should
everyone
just-
can hear what you're saying. And settle down,
I think
just
even my-
relax. The chair is too high, you are short. Just relax and make yourself comfortable and assist us.
My apologies, Chair. I'll do my best. Let's get to the relevant events of why you're here. You have already explained that you have 23 years of experience as a prosecutor.
Oh. Yes.
Okay. And you said until 2021.
Yes.
Right. Can you explain how you your duties where you were the first time when you were, which was in, you said in 2012, was it?
Yes.
Can you
Yes.
just outline that?
My duties as an acting Director of Public Prosecutions and a Director of Public Prosecution subsequent to that was to direct criminal prosecutions and all matters incidental thereto in the province of KwaZulu-Natal and then in the province of the Northwest when I moved to the Northwest. Basically overseeing all criminal prosecutions and any other matters that are incidental thereto as per the duties of a DPP. I think it's in Section 20. Yes.
Section 20 of?
The NPA Act 32 of 1998.
Thank you. Now, when were you appointed as a DPP of KZN?
Acting or permanent?
Acting.
Around July 2012.
Okay. And you acted until when?
The following year, in September 2013, that's when I was appointed permanently into the position.
Okay. And you said your duties were to oversee all the criminal cases in the KZN province at the time.
Yes, that's the general description of a duty of any DPP.
Okay. Now let's get to your personally.
Okay.
Just raise a point that might explain, and you place it on record, as to why the inquiry called to, instead of the evidence leading team. Paragraph 5, you state that before you give evidence, you'd like to explain. You can go to that paragraph 5 and set out very briefly what you wish to state, because there is a reason why you are no longer called by the evidence leading team.
Yes, sure.
That, or rather, the advocates that you had initially consulted with.
Yes, sure.
And subsequent to certain developments, you now had to be called at the instance of the panel.
Yes.
Do you wish to go through that briefly from paragraph 5 and just explain it using your own language, very briefly, and place it on record?
Okay, Chair. My explanation is twofold, but very short and straight to the point. The first one being that we had a misunderstanding with the evidence leader as far as me, which side of the parties am I going to testify for. I said I can testify for the commission or for Advocate Chauke, but I cannot be testifying, being led by the evidence leader, putting out the position that supports the NPA's position as far as the Ketomena case is concerned, due to the fact that I was part of this case and I supported the prosecution of this case at some stage. After Advocate Chauke, I became the one who was instructed to oversee the case. And I did not believe that I should be on the side that supports or that is against the prosecution of the case. And the second part of my explanation that I can give was that my position was not clearly enumerated to the panel, to the inquiry. An impression was created that I was refusing to come to testify. I changed colors, I dropped them, whereas that is not the position, and I felt it was unfair to me and really not good to my name to be labeled like that. Whereas the background and the context of how it came about, of me saying I cannot be testifying on the other side, had been given and it's known. And besides, I was not even scheduled to come testify on the 26th of January 2026 for me to be labeled as having caused or being part of the reasons that had caused the collapse of the inquiry schedule on the 26th of January. So I felt it was unfair, and that's what I just needed to clarify. And I am happy to be here as a witness for the Commissioner of the Inquiry, or for Advocate Chauke, but now I am a witness for the inquiry, and that's what I've been saying from the onset.
I suppose you now understand that the evidence leading team
Yes, Chair.
is not acting for anyone. They are appointed to present all evidence, be it favorable to Advocate Chauke or favorable to NPA. They have to maintain that neutrality. And there seemed to have been a misunderstanding that you wish to testify in favor of Advocate Chauke's team. So it was still appropriate, even
Yes,
if
Chair.
they called you
Oh,
to testify, because their task is to gather evidence, be it favorable to Advocate Chauke or not, but their task is to bring all evidence before us,
okay,
all
sure.
relevant evidence. So I just wanted to also clarify it to you,
Okay, thank you,
but we
Chair.
still appreciate that you nonetheless came.
Yes, thank you, Chair. Thank you.
Thank you, Advocate Poe. I think that aspect of the process has now been explained, and you may just get to the crux of the matter if you wish.
Thank you, Chair. And I just need to apologize to the Chauke team. I forgot to give you a physical file of annexures.
Speak to the mic.
Sorry, I was saying I just forgot to give the Chauke team their bundle of annexures. I wanted to apologize for that.
Yes, thank you.
Thank you, Chair. Advocate Noko, you just explained that you had been dealing with the Katomana matter.
Yes.
How did you come to learn of the Katomana matter?
During March or April, around there, 2014, I was invited to a meeting in head office with the prosecution team in the Katomana matter. The NDPP was advocating Mr. Ngasana, Mxolisi Ngasana. So they invited me to head office, and we attended that meeting. It was Advocate Chauke, the prosecution team, and myself. I didn't know why I was invited, but then I got to understand that the reason why I was invited into that meeting was for me, for Mr. Ngasana to instruct me to start taking over from Advocate Chauke. And then his reason was that because the matter resorted within my jurisdiction of KwaZulu-Natal. So that's when I started now actively being in the case as somebody, the DPP who was overseeing the case.
Was that the first time you encountered the Katomana matter in 2014?
No, it was not for the first time, but I was not overseeing it then. For example, when you look at the beginning, I think it's MN1, it will tell you that already I was informed about the case out of courtesy and also out of other reasons that were necessary. For example, in MN1, it indicates that Advocate Chauke needed to request a judge from outside of KwaZulu-Natal to preside over the Ketomena matter. As a result, he came to me as the DPP in that province to go see the judge president to put up that request to him. So already I had an idea, and he had given me his report there. So I had an overview of what is happening in that case.
Yeah, I think for purposes of chronology,
Yeah.
let's start to where you first encountered this matter, and you
Okay.
said, can you just outline that? How did it come chronologically instead
Yes.
of going to 2014 and then going back?
Yeah.
Let's do it like that.
Okay.
You started acting in 2012, you said?
Yeah, in around July. Then the following month, it was August 2012. That's when then I was approached by my colleague Advocate Chauke to say he needs to come to KZN. Then we agreed. Then he came to my office in Durban. I was in the Durban office then. There was 2 offices, Peter Maritzburg and Durban. So he came to my Durban office. I think it was on the 9th of August 2012. And then he briefed me to say, there's this case called Ketomena. This is what is happening. The police officers are accused of killing people and committing other offenses and all of that. The prosecutors, there's a team of prosecutors that has been formed, established, that are dealing with this case. And all the prosecutors are from outside of KZN. The investigation team from the police and the IPID, Independent Police Investigative Directorate, were also from outside of KZN. And the reason being that why now a presiding officer is sought, the one that would come from outside of KZN, was because the judges, in the presiding officers in KZN, had already dealt professionally, obviously, along with the prosecutors, with the accused persons. And even some credibility findings had been made in respect of some or most of the accused persons. So he wanted me to accompany him. So on the following day, on the 10th of August, then we went to see the judge president of KwaZulu-Natal in his chambers in Durban. So when we got there, Advocate, yeah.
Sorry, before you get there,
Yeah.
you said something about Annexure MN1 as you were speaking.
Yes.
Can we quickly go to Annexure MN1 that you were speaking of?
Okay. I have it.
Have it? Chair, during the printing of the annexures, the MN1 that is in the file does not have certain pages, and the top part is cut off. So we prepared clearer copies of MN1. I beg leave to hand them up as they have been handed up. And there would be would start at page 1 of the annexure bundle.
Yes, we do have these documents already copied for us, the purpose of reading. As you hand them up, I don't know whether you prefer that we mark them as exhibits, because we have a list of exhibits. Alternatively, your colleagues will assist you to compile these documents as we did initially with regard to Advocate Batoi. You can then compile all these exhibits from the annexures that we are marking, so that we know that we are continuing with the list of exhibits. I think the NPA team, I see council is nodding. Thank you very much. You can assist to continue from where we ended with the exhibits. You can hand it up now as you have done as MN1, and then later you can now put them together as exhibits, so that we can be consistent with the way we are marking these documents. I suppose Advocate Andrew will not be opposed to that?
No, Madam Chair.
Yes, thank you, sir.
Appreciate it.
Thank you, ma'am.
Thank you, Chair.
Sorry, I interrupted you. You had just referred to the document and handed it up. You may proceed.
During your testimony, you explained that you received an internal memo outlining the case. Is MN1 the document you were testifying about?
Yes.
In our documents, you can refer to the red bolded documents and then give it that name as it is in quotation marks. MN1 00001. This is why we have been proceeding with the paginated documents.
Yes.
It's nicely paginated, by the way.
Yes. Thank you.
Thank you very much.
Thank you, Chair. And you further explained that the document was the one that gave you insight into the Katamena matter.
Yes, this is the document. However, there are attachments.
Okay.
It had attachments as well, also that gave further insight. And I think even a prosecution memo was attached. I don't know, but yeah, it gave me insight into the case.
Before I interrupted you about that annexure, you were explaining that you were accompanying Advocate Chauke to a meeting. Can you continue from there?
Yes, on the following day, it was the 10th of August, 2012. I think it was a Friday. Then we went, myself and Advocate Chauke, we went to the Durban Chambers of the High Court, and then we met the Judge President of KZN. Oh, my throat. And there, Advocate Chauke explained the reason for our meeting, our visit, which was to request him specifically to assist in the allocation of a judge from outside of KZN, and explaining, the reasons behind that. And then the Judge President said he wanted this request to be covered by my cover memo or cover letter as the DPP in KZN. So that was the resolution, and also that cover letter of mine must attach this MN1, this memo from Advocate Chauke, and I must send it to the Judge President the following Monday, which would have been the 13th. I'm sorry, Chair, my throat is a bit irritated. Change of weather. I was not home in Gauteng. I only arrived yesterday from another province. So the aircons at the airport were terrible. So
We understand, ma'am. We understand. Take your time.
yeah, it's just my throat. I'm not nervous or anything. I'm just relaxed. Yes, I'm not at all. Okay. So
I am pleased to hear
yes.
that you are not nervous.
I'm not.
And you have our backing to protect
Thank you.
as the witness
Thank you.
of the inquiry.
Thank you. I
And
appreciate
you have
it.
already told us that you are here
Yes.
to speak the truth.
Yes, I am.
And I believe you.
Yes, thank you, Chair.
Yes, thank you.
Okay, so the resolution in that meeting was that I must prepare a cover letter, obviously with DPP KZN letterhead. I sign it, and I attach Advocate Chauke's request for an outside judge. This memo from Advocate Chauke does not only talk about outside judge, it gives a little bit of background and all of that on the case. So the JP would have also been appraised of the case. But it
Okay.
was also verbally communicated to him in the meeting. So the resolution was that I prepare that memo and send it to the JP's office the following Monday, being the 13th of August. And I did that. And my cover memo is as per MN2, which says, can I read it? It's just a,
Sorry, hold on before you read it.
okay.
Chair, MN2 appears on paginated MN00004. Does it appear like that in your papers as well?
Yes, it does. However, it's also marked underneath MN2 with a marker.
And is it
Yes,
complete?
for convenience and consistency, you can refer to the paginated numbers in bold red and then the bold black
Yes, Chair, I will do that.
in the quotation marks,
Yes, Chair.
just for the purpose of the record.
Yes, Chair, I will do that.
And at the time that Advocate Chauke was, you were accompanying him to the judge president,
Yes.
what was his position? What was he doing?
He was the Director of Public Prosecutions, as he still is.
Where?
Director of Public Prosecutions for South Gauteng Division, Johannesburg.
And why was he the one doing that one in KZN?
My understanding was that the then NDPP had allocated the case to him to oversee, and then he established a team of prosecutors comprising of 3 deputy DPPs and 3 senior state advocates. Yeah, so he was overseeing the case then.
And who told you that?
He told me that.
The said NDPP then was who?
It was the acting NDPP advocate Nomqobo Jiba then.
And why was it allocated to him?
I don't know really.
And you didn't find it untoward, bizarre?
It was how it was. I really did not. Yeah, I don't know.
Before you proceed, if I may follow up on that,
Yes.
is it allowed that a DPP of another division oversee or lead a prosecution team in another jurisdiction?
My understanding is that there's nothing weird about it. Because, for example, let me start with prosecutors from below the DPP, which is deputy DPPs and below. They can be delegated to go prosecute in another province. For example, in the very same Katomena case, the former acting DPP Advocate Simpiwe Mlojwa had issued delegations for this very team of prosecutors in the Katomena case. And as far as the DPPs are concerned, as much as the Act appoints them for a particular division, my understanding is that as the head of the organization, the NPA as a whole, the NDPP may, delegate or give ad hoc duties to any DPP to go do matters wherever in the country. That was my understanding. That's why I didn't find it odd. And I'm not aware of any legislation that says one cannot do that, honestly. That is why I really didn't find it off.
Thank you, Chair.
Thank you. Did I hear you saying earlier that some of the judges in KZN had made certain credibility findings in respect of those matters involving the Katomena cases?
No, credibility findings in respect of other cases, because they were investigators in KZN, so they would go and testify in courts in various cases. So meaning, I'm using Setswana. I'm sorry, Chair.
No. By all means, we have 11 languages in this country.
Okay.
If it is convenient for you to even express yourself in Setswana, because I know you speak Setswana, feel free to do that. Sometimes certain English concepts escape us.
Yeah.
So it's okay to say hore. Most of us understand, and if you get a word eludes you,
yes,
you can say it in Setswana, and then you'll remember as you go along.
Thank
so
you.
Feel free to say it the way it is convenient for you.
Yes, thank you.
Thank you.
Thank you. Sorry, where was I? Thank you, Chair.
The question was whether you had said earlier that certain members such judges had
Oh, yes. Thank you. I remember.
credibility finding.
Yes, I remember. No, Chair, the credibility findings was about them dealing with the accused persons in various cases, different cases in the province. As we know, investigators would go and testify in courts on matters, and the presiding officers would make credibility findings, whether they were good or bad witnesses, things like those. So meaning that the presiding officers and the prosecutors as well had professionally dealt with the accused persons already for them not to be in a position to be dealing with this case. And that was the request from IPIT and the police, as I was made to understand then, not in the Katomena case, Chair.
And these accused persons you are referring to included some of those in relation to the Katomena dockets or cases?
Yes, we were talking about them, the accused in the Katomena cases.
Yes, thank you.
Yes.
You may proceed, Madam.
May I, Chair? Thank you. Advocate Noko,
Yes.
can you just advise and actually indicate as to whether, according to your knowledge, there is a difference between exercising prosecutorial authority end doing oversight work over a team at the instance of the NDPP?
Okay, thank you, ma'am. My understanding is that they overlap. The line is very thin, basically. However, I would describe the prosecutorial authority one to mean you're getting more involved into the case, like making decisions to say, I'm charging this person or I'm not charging this person with whatever charge, like getting insight, being hands-in. Whereas the oversight one, I would describe it as being hands-on. You oversee, you get reported to and updated and all of that. So, because that is what had happened to me when I was overseeing. So, my understanding was that the overseeing before myself, like before I came into the case, was the same, and that's my understanding. With me, the oversight was they would update me, okay, this is what is happening, and not always. Sometimes I would find out later, and then they will update me later, but yeah, and they will tell me what is happening in the case, and whenever there are things to be signed by myself, then they will bring to me, explain to me, and then I would sign them. Yes, that's how I understand them.
Thank you. A follow-up. What you have just described here is a description in general terms.
Yes.
In terms of what is oversight, what you understand a prosecutorial authority to mean.
Yes.
Now, I think we need to then bring those concepts into the context of this inquiry that we
Yes.
are holding. Looking at the information that is at your disposal regarding this matter in particular, would you say that Advocate Chauke was exercising the oversight at his own authority or at the instance of the NDPP?
Thank you. My understanding was that it was at the instance of the NDPP, because I wouldn't think he will on his own, like move from his own jurisdiction and go to another to deal with a matter. So it must have been an instruction to him to say, deal with this case, oversee it, and that is what he explained to me.
Now, is your assumption that it must have been at the instance of the NDPP? Is it based on any documents that you have come across as you were dealing with this matter? Or is it based purely on what you were told?
It is based on purely on what I was told. I've never seen a document to that effect from the
Thank you.
NDPP.
Thank you. Thank you, ma'am.
Thank you, ma'am.
I think while you're still there, I think for clarification, when you were giving your testimony, you said a DPP can be delegated, and you just said that in this one you never saw any document. How are they normally delegated?
I have no knowledge, honestly, of any DPP having been delegated to go to do some work in another province. However, I have seen written delegations of prosecutors from the level of deputy DPP downwards having been delegated to go deal with matters in other jurisdictions. So with this one, really, I haven't, but that was my understanding, because I never heard anything from the NDPP side querying it or anything like that. So That was my understanding. And he also explained to me that he was tasked to do that.
Paragraph 13 of your affidavit.
Yes.
The last line, the last sentence after a semicolon, you refer to the consent letter by Advocate Johan Smith.
Yes, Chair.
Was it a letter of delegation, or what was that letter?
It was a consent letter in terms of Section 111 of the Criminal Procedure Act 51 of 1977, to the effect that as the DPP of the Northwest Province then, he's consenting to have this one case where the Ketomena members or accused persons are also accused to have committed offenses in. Basically, one of the allegations is that they committed offenses in the Northwest, in Rustenburg, which fell under his jurisdiction as the DPP. So in terms of Section 111 of the Criminal Procedure Act, that DPP must give consent in writing to say, I agree to give you this case to go deal with it in your area. And usually the criteria would be because most of the witnesses are in that area where that case is being moved to. The accused are there, the family members of the witnesses, of the accused, is in the interest of justice in general. And it's just one case from Northwest in this instance to many others that were alleged to have been committed in the KwaZulu-Natal. So it wouldn't have been okay, or even in the interest of justice, and it would have been prejudicial to the accused as well, even financially, to have to move and witnesses as well. So in that instance, a DPP is then requested to say, can you give us this case? We will deal with it where it's most convenient and most in the interest of justice to do. Then he consented to have that case from Rustenburg dealt with in KZN along with the others.
And you are aware that a team of prosecutors was put together, and that team included Advocate Maema, who was at that time working with Advocate Johan Smith.
Yes, Chair. Advocate Maema was the deputy to Advocate Johan Smith as a deputy DPP, but he was now allocated to the Ketomena case as a lead prosecutor. He was one of the 3 deputies that were in the case.
It then follows, if my understanding is correct, that it is possible to have advocates from one division, province, authorized to perform prosecutorial functions in another province.
Yes, it is possible to have a prosecutor from one province going to KZN or any other division to deal with matters. Yes. The same applied to the other deputies. One was from the Free State, Advocate Jabulani Mlojwa. Advocate Matenjwa was from Advocate Chauke's office in Johannesburg. And the 3 state advocates were from Johannesburg, Advocate Chauke's office. I don't know if I answered fully.
Do Advocate Mlojwa, was he from, you said?
The Free State
The Free
Division,
State.
yes.
And Advocate Matenjwa was from the office of the DPP, South Gauteng?
Yes, Chair. Thank you, Chair.
Thank you, Chair. Advocate Noko,
Yes, ma'am.
there is a difference between a delegation of authority and consenting to a prosecutor going to do prosecutorial functions elsewhere. Is that correct?
Yes, I can say so.
Now here, what we are talking about, or what your affidavit is talking about in paragraph 13, it is about just a formality that Advocate Johann Smith would be consenting to stated prosecutors to go and discharge prosecutorial work in another province.
No, in paragraph 13,
Yes.
the consent
Yes.
that Advocate Smith had given, issued, it's not about prosecutors. It's about a case, one case, that involves the Katomena accused people, that he's consenting to say it can be taken from his jurisdiction and be combined with all the Katomena cases and be dealt with in KZN. It is not about prosecutors, it's about the case.
Okay, yeah. Thank you. Like it would appear in this case, it was more about convenience. Convenience in terms of finances, family, and everyone, that this consent was given. And also maybe for the consolidation of the matters.
Yes, and it happens in other cases as well.
Okay.
That's why there's this provision in the Criminal Procedure Act. So we have done a lot of this. Yes.
Now maybe back to the issue of delegation,
Yes.
delegation of powers.
Yes.
Are you saying that it is correct that delegations can be done maybe by the directors of public prosecution in respect of the prosecutors below their rank? Maybe to make it simpler, to say the director of public prosecutions, it would be an anomaly to see him or her going to discharge prosecutorial functions like prosecuting in another province. Is that correct?
I would say it's an anomaly because that's not what we were used to. Only for those below the DPPs, yes.
Yeah, those below the DPPs can be allowed to go and prosecute in other provinces. Now, bearing that in mind,
Yes.
you know the status of members of the team that was constituted in order to go and do work that relates to the Katomena.
Yes.
Now, the status of all those prosecutors, is it such that they fall below the prohibited or they're not allowed or not prescribed for functions of doing prosecutions in other provinces?
First of all, to be clear, I'm not sure if DPPs are prohibited. I just know that we were appointed for a particular division, but there's no provision that says you are prohibited to go to another division. Honestly, I'm not aware of that. So I can't really use the word prohibited, but I can say, I know, I'm aware, and it has happened in a lot of cases where those that are of the rank below the DPP and downwards, yes, are sent all over the country as and when it's necessary for whatever reasons that may be present. But for the DPP, yes, it was the first one I came across.
Yes, the question is about the team. Remember that there's a team that is doing particular work.
Yes.
And there is someone who has been appointed to do oversight
Yes.
over the team.
Yes.
Now, this question that I'm asking,
Yes.
it concerns the team in particular. And
Yes.
I'm talking about the qualification of the team,
Yes.
not the person that has been appointed to do oversight. And the
Yes.
question is, that crop of people, that team,
Yes.
is it the team that falls below the directors of public
Oh,
prosecutions?
yes. It is the team that falls below the rank of DPPs, deputies, and downwards, yes.
Okay, thank you, ma'am.
Thank you.
Thanks.
ma'am.
Pardon, we interrupted you when you had just introduced NM2,
Oh, yes.
which was your covering letter
Yes.
as per the request of the judge president.
Yes, Chair. I was asking if I can read it. It's just 2.5 lines so that it's clear.
Yes, and actually it is appropriate
Oh, yes.
where
Thank
you
Chair.
consider it relevant and you want to say it correctly.
Yes.
You
Oh,
can read certain portions of your statement into the record,
Oh,
guided by the advocate, Advocate Kowe,
yes.
because you may not explain everything
Clearly.
without reading
Yes.
the affidavit.
Yes.
So
Thank you,
where
Chair.
you consider relevant to give a detail, you can read the paragraphs into
Yes.
the record.
Yes. Okay. Thank you, Chair. So MN quadruple 04 underneath MN2 is the cover letter that I prepared. Well, I realized when printing they cut off the letterheads. Even MN1 doesn't have letterheads, but they did have. So it's addressed to the Judge President of KwaZulu-Natal. It's from myself, and the subject is National Prosecution. It says, as discussed in our meeting of 10 August 2012, kindly find the attached memorandum in respect of this case from the Director of Public Prosecution, SGP, meaning South Gauteng Province, Johannesburg, for your consideration, and then I signed it. Then my office, my PA sent it to the Judge President's PA, attaching Advocate Chauke's memo, the MN1.
Thank you, madam.
And then you explained, that you had learned that this Catamena matter comprised of several dockets. Can you just explain what this Catamena matter comprised of when you found out, or what you learned?
Okay. This explanation is in MN1. I don't know how to answer that. Should I read this, explaining, or?
I think
You can go to I beg your pardon. You can go to paragraph 17.
Yes.
It flows from
Yeah.
what then transpired after the judge president had asked you to prepare a covering letter
Yes.
under your letterhead.
Yes.
As I read it, paragraph 17 then flows from then what you
yes.
found out.
Yes.
You can deal with that. I'm sorry,
Yes.
madam.
Thank you, Chair.
Is that where you are going now? Yes.
That
You
is
can
where I
go
was going.
paragraph by paragraph. It is fine.
Okay. I'm saying here, around this time, I learned that the Ketomena case comprised of several case dockets, 23, with several charges including several counts of murder, 28, and that the accused persons were members of the South African Police Service, SAPS, attached to the Serious Violent Crime Unit based in the Ketomena in KZN. And further, that the case was allocated to a prosecution team comprising of prosecutors from outside KZN, namely Advocate Sello Maema, Deputy from the DPP Northwest, Advocate Raymond Matenjwa, Deputy from DPP South Gauteng, Advocate Jabulani Mlotshwa, Deputy from DPP Free State, Advocate Mahlubi Ntlagaza, Senior State Advocate from South Gauteng, DPP South Gauteng, Advocate Pumeza Fuchane, Senior State Advocate from DPP South Gauteng, and Advocate Patience Moleko, Senior State Advocate from DPP South Gauteng. Yes, and then that the team and that Advocate Simpiwe Molojo had issued the 3 senior state advocates in this prosecution team with the necessary delegations to prosecute in this case. In KZN, as he was then the acting DPP of KZN.
Do you have a side of those delegations by Advocate Mlocho, if any?
Yes, I did. I just don't have them anymore, but I did see them.
Yes, thank you.
You can continue.
Counsel, you can take the witness through paragraph and paragraph if you make
From, yeah,
you want to make some progress. You can go to
Paragraph 19.
as to what then transpired. In 2014,
Yes, okay. Thank you, Chair. Sometime during the first quarter of 2014, I was invited to and attended a meeting at the National Prosecuting Authority NPA head office in Pretoria with the NDPP, Mr. Mqolisi Nqasana, the Deputy NDPP, Dr. Silas Ramaite, Advocate Chauke, and the Ketomena prosecution team. I can go on.
It is clear
Oh.
from that paragraph, from the
Yes.
reading of that paragraph, that at that time, the acting NDPP Advocate Nomkobo Jiba was no longer in that position.
Yes, Chair, that is so.
Advocate Mqolisi Nqasana was now the NDPP
Yes, Mr.
in
Yeah.
yes in 2014.
Yes, Chair.
and then what happened?
Okay, and then I was informed that the purpose of the meeting was for the prosecution team to brief the NDPP and the deputy NDPP on the case. At that meeting, Mr. Nqasana instructed that I be the DPP that was to oversee the case from then onwards and not Advocate Chauke anymore, as this case fell within my jurisdiction, KZN jurisdiction. And then given the fact...
Sorry,
Oh, sorry.
before you proceed,
Okay.
you say, as this fell within my KZN jurisdiction, before that, didn't it fall within your jurisdiction?
No, I'm not saying as it then fell. I'm saying as this case fell.
Within your jurisdiction?
Yes,
And
it fell
wha-
since the beginning.
Since the beginning?
Yes.
And you are saying that Mr. Nqasana instructed that you be the DPP that was to oversee the case from then onwards and not Advocate Chauke anymore, as this fell within my KZN jurisdiction. Can you just explain that, clarify that?
Maybe I didn't put it correctly as I was typing the affidavit.
Mm.
What I mean by that, that is the reason he said, I must be the one now to start overseeing it. He said, since this case is in your jurisdiction, you are the one who's supposed to oversee it and not Advocate Chauke. So from now onwards, Advocate Chauke must not oversee it anymore, and I must take over. So it's in that context.
And when this was said to you, what was the impression of what impression did you get? Because earlier on, when Advocate Jiba was still the acting NDPP at the time, there were no issues with Advocate Chauke overseeing it, even though it was not within his jurisdiction. And when Mr. Ngasana came in, then it has to go to you because it's within your jurisdiction.
I do not know what the issue was,
Okay.
but as we know, we have different ways of doing things.
Yeah.
Even management and leadership styles, we do it differently. So one can do something in this way. The very same thing is changed by someone who comes, the successor thereof changes from how the predecessor was doing things. So my understanding was that that's how he wanted the case to be conducted.
Right. You can continue to paragraph 21.
Thank you. Given the fact that I was instructed to oversee that case, I was invited to attend a meeting in July 2015, that is the following year, at the NPA head office. The NDPP had changed now. It was now Advocate Sean Abrams. The meeting was for the prosecution team to brief Advocate Abrams on the case, and the briefing included a slide presentation as well by the prosecution team.
Okay.
And then following that meeting, the prosecution team, through Advocate Maema, as the lead prosecutor, presented me with a prosecution memorandum, the indictment and other documents illustrating the case against the accused persons, and the need for racketeering authorization certificates to be recommended against some of the accused persons. And then I signed and forwarded to the NDPP these documents under my covering letter, as required by protocol and practice, that a DPP is the one to sign and forward any correspondence to the NDPP. Then the following year, in February 2016, Advocate Abrams issued the racketeering authorization certificates. I was informed that the prosecution team was regularly briefing and updating Advocate Abrams on the case and the development, as some of them, being Advocates Maema, Matenjwa and Mloja, were then based at head office in the Priority Crimes Litigation Unit, the PCLU. And the case dockets and all other case materials remained in the possession of the prosecution team and were, according to them, stored at the PCLU offices at head office. And then verbally and in their prosecution memorandum and other documents and statements, the prosecution team presented to me that a proper case had been made out of the prosecution of the charged people, and stated in the prosecution memorandum, I quoted what they mentioned there, that the prosecution in this case is based on the activities of such section of the Durban organized crime based in Ketomena. These activities, as depicted in the indictment, were committed by the accused acting unlawfully and under the veil of their employment as members of the SAPS during the periods May 2008 and September 2011. The accused killed the deceased under the pretext that they were investigating criminal offenses against them. The common modus operandi in all the crime scenes was that the accused would kill a person and thereafter place a firearm next to the body of the deceased to create the impression that the deceased was posing some danger to their lives, to make the shooting justifiable in terms of Section 49, subsection 2 of the Criminal Procedure Act 51 of 1977. And reportedly, 28 people were killed by the accused persons and about 23 case dockets were opened in various districts within KwaZulu-Natal. The prosecution team unpacked and presented these various case dockets against the accused persons and presented that the state has evidence linking the entire members of the enterprise, including accused 1 up to missing others in between, and 28. The said accused were members of the Durban Organized Crime SVC section under the command and management of Major General Boysen, participated in more than one incident, as indicated in the indictment when executing the illegal activities of the
Chair,
enterprise.
this is too fast.
Oh, sorry.
I'm not sure what we are losing, whether it's the impact or, but we're trying to take notes.
Yes, I thought it is helpful because unless we stop her, she's reading her affidavit. She was at paragraph 26. But do take it slow
Oh, yes, I will
so
check.
that we can all understand your evidence. But I've been following you. You're reading from the affidavit.
Yes, Chair.
I thought it will help Advocate Gauteng just for completeness so that we don't miss anything in this evidence. All should go into the record to the extent it is relevant. So she had just finished paragraph 25. She's on paragraph 26. And as we go along, questions might arise. It will help that you also just go slow. Take your
Yes.
time. You were reading paragraph 26.
Yes, Chair.
Yes.
Okay, thank you. I will do
Some of the things, if you don't consider relevant, you may jump, but we will guide you. We
Yes,
will
Chair.
guide you.
Oh, thank you, Chair. Okay,
So
paragraph
through you, Chair,
27.
just
Oh.
to add just one thing through you, Chair, that the leader should also try to pace the witness. Where there's a need for emphasis, where there's no need to really deal with the full detail. Thank you, Chair.
Yes, thank you. Thank you, Madam. You were
Okay.
reading the second line or sentence of paragraph 26.
Oh,
Yes, you were there when we interrupted you. You can go back to that sentence. The prosecution team
Team.
unpacked and presented these various case dockets. You were
okay.
there?
Thank you, Chair. Yes, the prosecution team unpacked and presented these various case dockets against the accused persons and presented that, I quote, the state has evidence linking the entire members of the enterprise, including accused 1, 2, 3, 4, 5, 7, 8, 9, 10, 11, 13, 14, 15, 16, 25, 26, 27, and 28. The said accused were members of Durban Organized Crimes SVC section under the command and management of Major General Boysen, participated in more than one incident as indicated in the indictment when executing the illegal activities of the enterprise. The prosecution memorandum...
Before you proceed, and this is after the issuance of the racketeering authorization certificate by Advocate Ngasana, or rather Advocate Sean Abrams,
This was in support,
in support
yes, of the application or recommendation for him to do so,
to all.
to
Thank
issue
you.
the authorization.
Yes, thank you, thank you.
Thank you, Chair.
And as the DPP, who was then requested to oversee the matters
Yes.
by Advocate Ngasana, you said,
Yes.
you familiarized yourself with those dockets, I suppose.
I was given the prosecution memorandum, I was given the indictment, I was given some of the witness statements that the prosecution team felt are enough for me to understand. So those are the things I read, among others, and the slide presentation, but not the entire case docket. It was with them in Pretoria. I was in Durban, so they only gave me this as being sufficient for that.
When you say it was with them in Pretoria, are you referring to the NPPs at the head office?
Yes, at the PCLU, that's where they said the dockets and all materials were stored there.
Yes, thank you.
Yes, thank you, Chair. On paragraph 27, the prosecution memorandum illustrated an ongoing and continuous pattern of unlawful activities by members of the Ketomena unit by shooting and killing 28 people who were allegedly sought without warrants of arrest and search warrants for suspicions of having committed some criminal acts. Further, that in this matter, since firearms were found...
Take your time, don't rush.
I'm sorry.
Please.
I'll go slower, Chair.
The point made there, paragraph 27,
Yes.
that there were no warrants of arrest. What should we make of that?
My understanding was that these people were just sought, kicking doors, barging in whilst people were sleeping without warrant of arrest and apprehending them without warrants of arrest to show that these people are legally sought for some criminal, on suspicion of criminal offenses they may have committed. That was my understanding.
As a prosecutor of 23 years of experience, does it happen that such acts can happen without any warrants of arrest by a magistrate?
They shouldn't, Chair. But then in this case, I'm told they happened as part of the illegal activities that were being committed by the accused.
Yes, thank you. You may proceed.
Thanks, Chair. Just one thing. Advocate Noko,
Yes, ma'am.
are there exceptional circumstances where police could get into people's residences and arrest without the warrant of arrest? And also without search warrants? It's actually two questions in one because
Yes.
they are disjointed. I'm not saying and, but then it's in respect of the search warrants and on the other hand in respect of the warrants of arrest.
Yes, thank you, ma'am. It does happen that a person is arrested without a warrant of arrest. For example, in instances where a crime is committed in front of a police officer, he or she witnesses an offense. They can't go obtain a warrant of arrest. They just arrest there and then. Or sometimes the community has apprehended someone who's suspected of having committed a crime and is taken to the police station. There is no warrant of arrest and the police can process it from there. That is as far as the warrant of arrest is concerned. And as far as the search warrant is concerned, it also depends whether the interests of justice dictate. But the issue here in this case is, in all these cases, there's no warrant of arrest. I mean, the search warrants. There are no search warrants. In all these cases, it's an issue of kick and babosa. Doors are barged open and people are apprehended and all of that. So that was the complaint or the issue.
Thank you. Thanks.
Thank you, ma'am. Or should I proceed?
You were at paragraph 28.
Yes, thank you, Chair. I still need to read 28.
When we interrupted you, you were just about to deal with
28.
paragraph 28.
Oh,
You
thank
may
you, Chair.
paraphrase it if it is convenient for you,
Okay.
just very briefly.
Yes, the issue here was that the police created an impression at every scene of murder that the deceased people were posing some danger at them, and they are alleged to have planted firearms, which according to ballistic reports, most of them were not functional or did not match the cartridges that were found on the scene, things like that. So that is basically what it says. And then in paragraph 29, it says, none of the police officers got shot at. As per paragraph 28, it says, the deceased were posing danger to the people, to the police. But then in all those instances, none of them got any scratch from any bullet. Even their vehicles, none of them got shot at to show that indeed the deceased were shooting at them. So that also created an impression that it was not true what the police were saying, that they were being shot at or their lives were in danger from the deceased. And furthermore,
To such an extent that it could be said that the police were acting in self-defense?
if it was self-defense has bounds, Chair. If you exceed the bounds of self-defense, you become an aggressor yourself. So I would say personally, they became aggressors, if indeed they were, but we think they were not in danger because it hasn't been proven. All indications point to the fact that firearms were placed there. The deceased were shot in a supine position, lying down, sitting down, handcuffed, and all of that. So, yeah.
Yet, what you say dispels any notion that the police could have been attacked.
Yes, Chair. Meaning that it's not justified killings under Section 49, subsection 2 of the Criminal Procedure Act. It's not justified because they can only kill under those circumstances. It's justified. They were in danger. But even then, they must act reasonably, in moderation, like moderate force must be applied. But 28 people that have been reported can't all be killed under the same, should I call it modus operandi? There's a firearm there, but the deceased was handcuffed. The deceased was lying down. So that in itself shows there's something wrong here. Thank you, Chair. Furthermore, the ballistic experts in most of these murder cases indicated, for instance, where the accused persons created an impression that the deceased shot at them from inside a car, that the car's windows were closed and no indication that shots were fired through the closed windows from the inside. For example, in one case where Mr. Bongani Elfas Mkhize, who was the chairman of the KwaMaphumulo Taxi Association, was killed. He was driving, I think, a Lexus, black Lexus car or something like that, but he was driving along Umgeni Road, and then he was apprehended by the police, not apprehended per se, but was shot at in a rain of bullets. The police placed the firearm allegedly in his car, and the ballistic proved that there was no shot that came from outside, from inside the car. So that is one of the examples, and that is the one referred to in the first example. So the ballistic report dispelled that myth, and that the car's windows were closed and no indication that shots were fired through the closed windows from the inside. In other cases, some deceased were shot from the back whilst lying down or in a sleeping position. Some were shot at while in a sitting position and the shooter in a standing position. All this is established by ballistic analysis. So it also supports the prosecution's view that these people were just killed in cold murder. They were not posing danger to the police. And in some cases, the firearms next to the deceased were found to be defective and incapable of firing shots. And some indicate that they were lying or on their back or falling when shot at. And also the blood spatter pattern indicated that the firearm alleged to be that of the deceased was not there at the time of firing, thus confirming the subsequent planting of the firearm. In other instances, that indirect gunshots entered the dustbin This is in respect of one of the cases in Durban North, where the deceased had run away because he was being chased by the police, and he hid himself inside a dustbin. And allegedly he was shot while inside the dustbin several times. So ballistic also proved that there was no shots that were fired from inside the dustbin, but all the shots were fired from outside into the dustbin. So how could that type of an incident pose any danger to the police? That's just one of the instances.
Yes, all these, the scenarios, and please correct me if I am wrong, seems to point to one direction, that there existed, at the very least, a prima facie case for prosecution of those members,
Yes, Chair.
correct?
Correct, Chair.
And
pros-
whether,
Oh,
yes, you may.
Oh, no. Sorry to interrupt you, Chair. I was saying, yes, indeed, there existed prima facie case. And, Chair, you'll hear also from the witnesses' statements what they are saying. And then tallied with the ballistic reports, how the whole incident took place, you'll see a clear prima facie case that these people should have been prosecuted. And them not being prosecuted, I don't see it as justice at all to the deceased and their families. Also, so the prospect of a successful prosecution exist in this case.
Am I also correct that all these instances that we have explained
Yes.
supported the issuance of racketeering authorization certificates,
Yes, Chair.
at least at that time by Advocate Sean Abrahams?
Yes, because that is the time where I really got in. It did support the issuing of the authorization. So Advocate Abrams was correct to issue the racketeering because there appeared to be a pattern of illegal activities. I mean, 28 people killed in different, not at once, in different incidents. So there's this pattern. And firearms are there, the police are saying their lives were in danger. So there was that modus operandi. You can see a pattern being happening. That is why then the prosecution team opted to use the racketeering, the POCA, Prevention of Organized Crime Act, provisions and charge them with racketeering because they could establish a structure there which has management, there was a system of authority there was continuity, and there was a pattern of illegal activities with a common purpose. Because it's one and the same thing. You can see the modus operandi there.
Yes,
Thank you,
thank you.
Okay.
You had just finished explaining to us how somebody or one of the victims was shot at whilst he or she sought refuge in a dustbin.
Yes, it's
Paragraph
a he.
31.
Yes, it's a he, Chair. He had hidden himself in the dustbin, but he was killed whilst hiding in the dustbin, whilst he should have just been apprehended. Paragraph 32, based on the prosecution.
Proceed.
Okay.
I know you are going to go into Annexure MN3,
Yes.
which might necessitate a closer reading. Remember,
Yes.
we only obtained these documents yesterday.
Yes, yes.
Perhaps, as my sister Advocate Baloy is reminding me, we should pause for 15 minutes for tea.
Okay.
Advocate Kowe and your team, Advocate Kwaitobi, we think that we can pause for a tea break. we will resume at 25 to 12.
Okay. Thank you, Chair.
Will 15 minutes suffice? Might I propose that we adjourn for 30 minutes? That will enable us to quickly peruse the annexes. We received them very late. So 30 minutes. You will also just maybe reflect
Yes, Chair.
and on your evidence and as you take us through your affidavit.
Yes, Chair.
Advocate Kowe, Advocate Gaitobi will adjourn until 11:45. Thank you. Good afternoon, not yet. Advocate Kowe, Advocate Noko, I forgot when we adjourned to remind you that you are still under oath. You know why a witness would ordinarily be warned, but as a seasoned lawyer, you know you cannot discuss with anybody.
Yes, Chair.
Let me remind you that you are still under oath, madam.
Yes, Chair.
Yes, thank you.
Thank you.
You may proceed, Advocate Kowe. Or maybe let me take you to the paragraph where you were, when we adjourned. I think it's paragraph 32. You were just going to deal with that paragraph when you adjourned, and reference is made to annexure MN3, page 10. Would you like to deal with the contents of that paragraph 32?
Oh, it's for me, Chair. Oh, thank you, Chair. MN3, Chair, is a report that I had written in response to Advocate Shamila Batohi in 2020. The one I'm referring to here, that I sent to her, is dated 15 September 2020. But I see they attached as MN3 a different one. The contents are the same, really. It's just the addressee are different. So it will still serve the purpose as far as the contents are concerned.
Okay, let's get that correct.
Okay, yes, Chair.
This report
Yes.
that you filed summarizes certain dockets, correct?
Yes, Chair.
In relation to the Katomena case,
Yes, all the dockets, actually.
all the dockets.
Yes, Chair.
And this MN3 appears as bolded red, MN00005
Yes.
marked MN3
Yes, Chair.
in quotation marks.
Yes.
Advocate Kowe, we are not taking over.
No, I understand, Chair. I think with the fact that I came in quite late and under pressure, I think there were certain aspects that I also had to go and look at again. So I understand that you're not taking over. Might need clarification.
Thank you. Along, we just trying to make sure that her testimony, comprehensive as it appears on paper, should be placed on record to the extent that we can. Otherwise, we have annexures, but the transcript should reflect the essence of her testimony. And as she is our witness, we will keep on interrupting, bear with us, so that we clarify certain aspects. Now, this MN quadruple 05 is dated 27 October 2020.
Yes, Chair.
It appears to me that this very document,
Yes.
you may not be aware of that, was also a document that was filed of record at the Zondo Commission. I'm looking at that very document. If you look at MN quadruple 05, on top there is written ZC 02532.
Oh, yes.
That signifies a Zondo Commission document.
Yes. Oh.
Do you have an idea as to how it landed at the Zondo Commission, this report of yours?
I was not even aware. Actually, I didn't even understand what the ZC and the number is. I don't know, Chair.
Yes, you have already been provided with the bundles.
Yes.
One of the bundles is in bundle 11.
Yes.
Advocate Andrew Bundle 11 of the ZCs at page ZC 02523. It's exactly this document that has just been filed. It's pages. Oh, beg your pardon. Yes, I was just saying, Madam, this document also formed part of the Zondo Commission
Correct.
bundles.
Yes.
Hence, we have this same document at bundles 11 of the 12, pages 002507 to 02764. Now, this document, your MN3,
Yes, Chair.
is replicated
Oh.
in this bundle. And I wanted to know from you whether you know why this document landed at the Zondo Commission, and you've just answered you don't know.
I don't know, Chair. Although the one that I was referring to was a different one. Similar contents, but my response to Advocate Batohi of the 15th September 2020. But it's almost the same thing, so I'm fine with this one as well. if it's
Okay, the one that you say is the correct one is the one which was sent to us online.
Yes, that's the one, Chair.
What is the date of that?
15 September 2020.
Advocate Kowe, where is that document? I read it, but I thought that the contents are the same, but maybe if you can just tell us, do you have it somewhere? Or we will check in our documents in chambers.
Thank you, Chair.
I'm sorry, Chair. Maybe if I can clarify, the purpose of this, mostly, these two reports, is to summarize each case. So they both serve that purpose equally, as far as those cases are concerned, unless they are different here and there with regards to other issues and cases that are not the one before the commission, before the inquiry. So I don't know if that helps.
Yes, the one that you filed of record earlier is dated 15
September 2020.
2020.
Yes,
2020.
yes.
Researcher is helping us, and he is right. It's in the correspondence file. These annexures,
Yes,
let me refer to the one dated 27 October 2020,
yes, Chair.
is not an affidavit, just a statement or a recordal of what you wanted to place before somebody.
Yes, Chair.
This one, dated to 27th of October 2020, was addressed to all prosecutors.
Yes, Chair.
And it came after the one that was addressed directly to Advocate Batoyi on the 15th of September 2020.
Yes, Chair.
The essence, as you have just said, of these documents
Yes, Chair.
are almost the same.
Yes, Chair.
Is it now convenient? Maybe you can start with the one that you addressed to Advocate Batoyi, because you said that she had asked you
Yes.
to explain certain things or directed a letter to you.
Yes, Chair.
What did she ask you to do?
It was, I think it was the previous one, in August 2020. She was asking me to respond to allegations that are there regarding those cases, including the Ketomena. So my 15 September 2020 report was in response thereto, but I don't have a copy. It was not part. It's not part of the bundle. But
Yes,
yes,
we do have that document, Advocate Chauke. I remember reading that document last week. We can proceed. I've asked my researchers to go and get copies of that document, which arose after the witness was asked by Advocate Batoyi to explain certain things. When it comes, we'll go back to it.
yes, Chair.
But this document of 27 October 2020,
Yes.
why did you write to all advocates, all your colleagues?
Chair, I was emotionally tired of being falsely accused of protecting certain people in certain cases, of doing things in cases that I did not do. The media was running the show about me on that one, and my colleagues in the NPA, some of them were feeding the media those lies. So I was tired. It had been many years, me trying to explain, to say, this is what has happened in this case. This is what has happened in this case. Then I felt maybe my colleagues need to know, not to get their approval or support or anything like that, just for them to hear from me. As a senior member of the NPA, being the DPP, and then I'm portrayed in that light. I was even associated with state capture and all of that. Just simply by doing my job, deciding as I did in certain cases which most of them, it's only one. All of them had prosecution teams like the Ketomena, but everything that they deem wrong was imputed on me. Like, I was emotionally tired. That's why I resigned, and I felt I was pushed to resign. That is the hardship, emotional hardship that I went through in the NPA. So I felt my colleagues maybe deserve to know, because they read the false stories in the media. I did this, I did that, I did not do that. And I've never gone out to the media to say that, because I was respecting the processes within the NPA. I've never spoken to the media trying to clarify that. And then I felt, let me tell my own colleagues so that they know what is happening in those cases. And that's when I penned this document, Chair. It was from there.
The introductory paragraphs of MN 0005, NM3, MN3.
Yes, Chair.
If you can read that into the record, paragraph 1 and 2, before you get to those cases.
Okay, it says, it is almost 10 years now that I'm being insulted, labeled and called names because of some of the cases that I dealt with when I was DPP in KZN. This vilification continues to this day, with the concomitant silence from my own employer, despite that I have sent my explanations. Even now, since the vilification against me has continued this year, I have responded and explained all these cases, my role and how I dealt with them to my employer. Now I cannot continue to stay silent while I am traumatized and made to feel like I'm parading naked in public due to this unfair and unjust treatment for simply doing my job. Below is my response to how I dealt with all 5 cases that I'm being constantly crucified for my role and decisions in. I have not attached the documents referred to herein as annexures due to their big volume, though. They are available on request if necessary. However, all these annexures have been sent to my employer along with my explanatory report to these cases. I need to state my version to you, as I feel that, as my colleagues, you deserve to know my side of the story, not to convince you or to seek your approval, because I am certain and confident with my story.
The next part, you are referring to those cases 1 to 5.
Yes, Chair.
The first case, the Durban Central 466/01/2011, concerns a certain Mr. Toshan Pandey and Colonel Madwe.
Yes,
Is that
Chair.
Madwe?
Madu.
Madu.
Madu, yes.
Yes, thank you. And you elaborate on this case at the next page,
Yes, Chair.
a page MN 0006,
Yes, Chair.
paragraphs 1, 2, 3. Would you place that on record?
Oh, okay. Yes, Chair, I will do that. Durban case.
Maybe before that.
Yes.
It may not be relevant, probably, but you have to indicate the relevance of that part that I said you must read into the record if it is relevant.
Yes.
This aspect, the Toshan Pandey case, is one of those Katomena cases, or rather the cases that relates to some of the members of the Katomena, especially Major General Boysons.
No, it's not.
It's not.
The reason why I mentioned it is because Major General Boysen has been saying he is being prosecuted in the Katomena case because we were trying to protect Toshan Pandey, Mr. Toshan Pandey, in this case. Meaning that my decision in the Toshan Pandey case is wrong. According to him, it is wrong. It was just to protect him so that he's prosecuted in the Katomena, like That is the theory that is there. So I'm mentioning it to say, this is how I dealt with this case, and these are my reasons. And not because General Boysen has been targeted in the Katomen. Yes.
Is there anything in relation to the Toshan Pande case and Madu case
Yes.
is of relevance here? His conduct or his Major General Boysen's conduct?
He is the complainant in this case.
He was the complainant.
Yes, with the allegation that these two, Mr. Toshan Pande and Colonel Nevin Madu, bribed him in respect of case 781 of 10 of 2010, the soccer FIFA World Cup. That is the next case after this one.
The third paragraph of that
Yes,
page
yes,
speaks of the conduct of Major General Boysens
yes, Chair.
having visited the victims or the accused himself
Yes,
at the prison
yes,
or at the cells.
at the police cells.
At the police cells.
Yes.
Is that conduct appropriate insofar as complainants are concerned?
It's very inappropriate, Chair. Complainants don't visit accused persons in their own cases. And there's a document to that effect that he issued an instruction to the station commissioner, Brigadier V.R. Stokes, to say these are the people that only these people are allowed to visit Mr. Madu when he was in prison, in the police cells. And he is number one in that list. That is why I'm saying it's inappropriate. And this confirms the police meddling in this case that is being alleged in the representations by these two accused people. And the other allegations as well regarding police meddling.
I take note of some of the contents of this report. I'm not sure whether anything else could be of relevance here as regards the conduct of Advocate Major General Boysens. I'm looking at the allegations in relation to Section 252 capital A of the CPA.
Yes.
If it is not relevant, do let us know, because we are more concerned with the conduct of the Katomena members
Yes.
more than just a broader issues. So anything else that may be of relevance in this document as regards the Katomena members?
No, it's only that one, his interference in terms of visiting the accused in his own case, and just me explaining where I came from with the decision to withdraw this case. That's all. Trying to say there's no protection of anyone here. This is what is happening in that case. So, yes, there's nothing else, Chair.
And very broadly, as I read this document,
Yes.
it seems to me, and correct me if my reading is incorrect,
Yes, Chair.
that you seem to have been expected to make certain decisions
Yes, Chair.
which were contrary to your prosecutorial
Yes.
discretionary power.
Yes.
Am I right?
Yes, Chair, because I'm seen as wrong in deciding the way I did, despite the reasons that I gave.
But who said that you were wrong in doing so?
Because Advocate Batohi was establishing a commission the same way as she has done with Advocate Chauke against me. That's when I felt I don't have the emotional strength for all of this, and I resigned. That's why I'm saying I was pushed to resign. Because I didn't understand how else must I explain this. Now I felt now I must be humiliated for this. Like, I couldn't take it anymore, Chair. I didn't want to resign, but I had to resign. I was pushed out. Not because I'm corrupt or I stole someone's money or anything, simply for doing my job the way I see fit. I tried to explain to say, my understanding is that you decide on what is before you, and if somebody does not agree with you, Section 179 of the Constitution, for example, gives the NDPP powers to review your decision. But don't punish the prosecutor for deciding as they did, despite the reasons that they give you to say, this is where I'm coming from. We have appeals in our legal system. A decision of a magistrate, for example, gets appealed in the High Court. The magistrate must not be punished for their decision. They have their own reasons in law why they decided on that. If they had evidence that there's some underhanded things happening for me to decide like this, but nothing like that. I explained, Chair, for many years, like I was tired. So I feel I was pushed out. I didn't have a choice. I had to resign.
And when did you resign?
In February 2021, Chair.
Chair. May I request a short pause?
Yes, Your pardon, I'm sorry. I was not watching.
I'm so sorry, Chair. I apologize.